So we mentioned this story yesterday because that's when the news, I guess, basically broke, because today is the day. Today, Bill 21, Quebec's secularism law, heading to the Supreme Court of Canada, with arguments from all parties having been filed as of yesterday. But now the crux of the debate, and this is where it gets interesting, will not apparently necessarily center around secularism, but rather around Quebec's preemptive use of the notwithstanding clause. And Quebec is not alone in this. So I thought we'd try to get some perspective. Pearl Eliadis is a human rights lawyer and associate professor at McGill University, and she is on the line. Pearl, as always, thank you for the time. A lot of people may be wondering, well, wait a sec, if this has gone all the way to the Supreme Court, and we know that the federal government is now involved, they're saying this will not specifically target, or I guess be targeting Bill 21. So what is going to be happening here?
So I think the Quebec government has taken the position publicly and vociferously that this is an attack on the will of the people, both Quebec and Canada, actually. I think the federal government's position is a slightly different one. They're very careful, and this is, I would call, a sort of surgical intervention. They're very careful not to take a position on Bill 21 at all. I think there are political reasons for that as a minority government with a budget coming up. But they do want clarification, and they're, I think, asking the court to provide that clarification on what exactly Section 33 is about and how far a government can go in eliminating entire swaths or swathes, I'm never quite sure how to pronounce that word, of people from constitutional protection. How bad does it need to get? And so the federal government's really saying, we would like some guidance on this, and I think this is important for two reasons. Number one, it actually is not taking a position on Bill 21, and therefore I think some of the Quebec response is not actually thinking about what the feds are trying to do. And the second reason is one that we've talked about before, Aaron, which is we didn't know and we don't know why the court granted leave to appeal. Of the many, many issues that the Quebec Court of Appeal dealt with, we don't really know which ones they were going to deal with. And that includes potentially Section 33 itself. And I think by specifically asking the court to let us know what the limits are, if any, on the substantial use of Section 33, we now have this door opening where we know the court will now directly address this issue. And I think that provides clarity and visibility.
So the one other issue in here that perhaps we have not talked a lot about is the fact that beyond Quebec, there are other provinces, of course, who will be presenting here and holding up the idea that, you know what, no, we need to be able to continue to use the notwithstanding clause, among them Ontario, New Brunswick, Manitoba. So the decision, whenever it's rendered, and by the way, I think I may have asked you this before, it's one thing to present. When can you expect a decision here? Is that a year away, 2 years away? Do I have any way to know?
No.
So it could take a long time, in other words.
It could.
Okay.
Could, yeah.
So the fact that these other provinces are involved to defend their positions of using, what does that change?
So I believe it's correct to say that the feds have never used the notwithstanding clause. It has historically been used by the provincial government to shield laws that otherwise would have been deemed to be unconstitutional. And the provinces are right to say, look, this was part of the deal. This was part of the constitutional deal in the lead up to, the entrenchment of the Constitution in 1982. This is what we agreed to as a country. We can't back down now. And that's, an argument that brings this idea of parliamentary sovereignty back into the equation, right? That we don't want it all only judges deciding. We want to make sure that we retain that power. And that's a defensible position to take. I don't understand the federal position, though, to be that we will no longer have access to Section 33. I think what they're asking the court to do is to let us know if there are any fences around it, and to let us know whether there are any considerations beyond the formal incantation, sort of the abracadabra, and all the rights disappear, and we don't have to worry about whether or not at a substantive level it's somehow justified. Whether there's more to it than the courts have talked about so far. And getting that clarification, I think, is going to be really important. So I think it's important not to overstate what the court is doing, what the federal government is doing. They're saying, let's talk about this as a society, and it's unfortunate, I think, that the Quebec government wants to shut that conversation down.
All right, Pearl, I thank you for the time. I have Andrew Caddell on. He is with the Task Force on Linguistic Policy. He's a regular contributor here on CJD. Andrew, this is the day I guess you've been waiting for a while, so bring us up to date on the position. You're the Task Force on Linguistic Policy position, and what you're hoping to see happen here.
Well, we're not challenging Bill 91, but we are
21. You're challenging 96.
We're challenging not Bill 96, but in this case, we are an intervener. We're among the 38 interveners. We have quite a novel and innovative position. We're not challenging the notwithstanding clause. We're challenging the notwithstanding clause alone, as it affects our Bill 96 case. But our lawyers have come up with a look at the whole constitutional framework of Canada and the United Kingdom, because we say we have a constitution similar to the United Kingdom.
Right.
And we look at British precedents and statutes, and we say, well, if the notwithstanding clause can wipe out all fundamental freedoms, then we have none. However, on the other hand, as what happened with the Charter in 1982, it certified or listed rights, but didn't create them. They already existed in British tradition all the way going back to the Magna Carta. So the notwithstanding clause can't take away rights. So what we're saying is that rights already existed before 1982, and therefore the notwithstanding clause is an indicator, but it's not the last word. And therefore we can, the notwithstanding clause could be sort of put in the garbage or put aside. And then Section 1 of the Charter, which says that there are reasonable limits in a fair and democratic society. That's the most important section. And that you have to refer to the rights that existed before 1982 because they still exist. And you cannot suppress or eliminate or cancel rights just by simply saying the notwithstanding clauses. Pearl said abracadabra and your rights are gone. So I think we're very, very positive. This is going to be an argument that the Supreme Court will listen to and could embrace.
Okay. As Pearl said, we're a long way away from an ultimate decision here. We've already heard from people within the CAQ government today, Simon-Jolin Barrette, Jean-François Roberge, saying this is using the back door, to use Simon-Jolin Barrette's words, of trying to circumvent or take Quebec's power away to use it. What do you make when you hear that?
Well, let's face it. Provincial governments are always going to be acting on behalf of provinces, and they are, by definition, very provincial. And that's why you see all those provinces lining up to support Quebec. On the other hand, the notwithstanding clause can't be used to just eliminate our fundamental freedoms. It can't be. Otherwise, the Charter's not worth the paper it's printed on. So what really has to happen is it goes back to Section 1, which says reasonable limits within a free and democratic society, and that's really what should be the litmus test. And it can't be that you just say, well, we're going to pass the notwithstanding clause. Sorry, you don't have any more. You don't have fundamental rights. And, for our case, we're going to have to raise a lot of money because this is a separate case from our Bill 96 case. But we really want to make this point because this is our opportunity to make a point that could be, as I say, and I'm sure will be embraced by the Supreme Court.
We have to leave it at that. Andrew, I'm sure you'll keep us up to date on what's going on as this case progresses. I appreciate the time today. Thanks so much.
Unmistakably Canadian.
It's the music that raised you.
The artists raising the bar.
Hi, this is Brian Adams.
Hey, my name's Brett Emmons. I'm from the Glorious Sons.
Hi, I'm Nelly Furtado.
Made in Canada. The station that champions Canadian music.
Loud, proud, and all yours.
No passports required. Just press play.
Tap into Made in Canada now on iHeartRadio.ca
or the free iHeartRadio app.